start. The appellants had to be granted future loss of income, which has not been granted by the tribunal without assigning any reason, The tribunal in its judgment deducted one-third for personal expenses, The deceased was working in the sugar mill since 1996, The salary of the deceased was rupees 14,536 per month, The salary slip was proved by PW4, The crushing season of the sugar mill was from November to May only, The mill, when it was not working, the salary was remained the same, but he would be paid half of the amount, The tribunal deducted 50% of rupees 1,30,824 as income tax, GPF, insurance, gratuity, which could not have been done as in the year 2015. The income of the deceased was rupees 1,30,824 per year, which was non-taxable income, The Supreme Court in the case of Bimal Kanwar and others versus Kishore Dan and others, 2013 under bracket 3 TAC 6:2013 under bracket 4 AWC 3282 under bracket SC held that the certain amounts cannot be deducted, hence we hold that rupees 1,30,824 was the annual income of the deceased, to which 30% will have to be added as the deceased died at the age of 43 years within bracket age bracket of 41 to 45 years will apply bracket out, He was survived by 2 minor children, mother and his widow, hence the deduction of 1/4 cannot be granted as requested by learned counsel for the appellant, but it would have to be 1/3 and not 1/4, The deceased died at the age of 43 years within bracket age bracket of 41 to 45 years bracket out, therefore, the multiplier would be 14, The tribunal has held that the deceased too negligent also in driving the vehicle, The reasoning given by the tribunal to hold the deceased negligent and that he had contributed to 50% of the accident is perverse, just because there was collision of 2 vehicles, and that the driver of the car was having valid driving license and the registration of the vehicle was there, and just because the license of the deceased was not produced before the tribunal, it cannot mean that he was negligent, The ocular evidence of PW3 on the contrary goes to show that the deceased was driving his motorcycle on his correct side, Thus, the finding on facts is not only bad in law but is perverse, therefore, we hold that the tribunal has committed an error in holding the deceased to have contributed negligence and due to which accident had taken place, The vehicle involved in the accident is car and motorcycle, The tribunal has given its finding just because of the fact that the driving license of the deceased was not produced, and only this fact will not permit us to hold that there was contributory negligence on the part of the deceased, Having heard the learned counsel for the parties, let us consider the negligence from the perspective of the law laid down, The term negligence means failure to exercise care towards others which a reasonable and prudent person would in a circumstance or taking action which such a reasonable person would not, Negligence can be both intentional or accidental, which is normally accidental,